Hello, I'm Jerry Theodorou, the director of the R Street Institute's Finance, Insurance, and Trade Program. Thank you for joining our webinar today, or if you're listening afterwards on the recorded version, third-party litigation funding, friend or foe. Our discussion will be recorded and available to all in about a week. We're lucky to have a great brain trust with us today. Michael Menapace is a partner in the litigation and insurance practice groups at Wiggin and Dana. He's a professor of insurance law at Quinnipiac University School of Law and a non-resident scholar at the III, the Insurance Information Institute. He's the author and the editor of numerous insurance and litigation books and articles, and is an in-demand speaker on insurance and cybersecurity issues. He's testified before the U.S. Senate Commerce Committee on cyber insurance. Caroline Melear is a resident fellow at the R Street Institute's Finance, Insurance, and Trade Program. Caroline has a strong background as an investment analyst and makes outsized contributions to R Street's public policy work, especially in the finance and insurance issues area. The third-party litigation funding is a phenomenon that until recently was relatively unknown, and it's gotten a lot more attention, especially in the last few months. In December, just 4 months ago, there was an episode of the TV show 60 Minutes where television journalist Leslie Stahl focused on exploring what is third-party litigation funding. And just last month, in March of 2023, the Wall Street Journal had an opinion piece by the journal's editorial board focusing on third-party litigation funding. So first of all, what is third-party litigation funding? Simply, it's the practice of third-party capital providers investing in lawsuits. And there's two elements that are key. First, the litigation funder is not a party to the suit. And second, the funder is not the plaintiff's legal counsel. And the funding can flow in one of two ways. It can go directly to a litigant, to a plaintiff, as a loan, as an advance, or, and this is what we'll be focusing on more today, it can go to the law firm, funding the law firm. And it could be for one suit, for one lawsuit, or it could fund an entire portfolio of lawsuits. And I'm really glad that Michael is here. I'm not a lawyer, so I'd love, Michael, if you could help us to unpack two of the big themes that seem to be swirling around the third-party litigation funding phenomenon on legal ethics and implications on disclosure. And thanks for joining us, Michael. Great to see you.
Of course, Jerry. It's great to be here. Thanks for having me. I appreciate it. Yeah, I'm happy to talk about both the ethical implications and then some of the debate that's going on about disclosure. The ethical implications really impact the lawyers who are advising their clients and taking on these cases. And some of that then overlaps with the disclosure requirements, which you'll see in a moment. But there really are three areas in which a lawyer needs to pay attention to, in particular with the litigation funding in his or her litigation. The first area is protecting privilege. The second is making sure the lawyer is not constrained and can give independent judgment to the client, the party, not the funder. And then the third is making sure that the lawyer can actually provide adequate guidance to the client before there is a funding arrangement entered into. And I'll unpack each of those here. So first on the privilege, the attorney-client privilege is designed to protect communications between the attorney and the attorney's client, in this case, the party to the lawsuit. And generally, we say that when those communications are divulged to third parties, the privilege is lost. It's waived. And so the question is, when a lawyer provides information to a funder, is that privilege waived? The funders, rightly so, before they make an investment in litigation, want to understand the relative strengths and weaknesses of the case. That very well may include having to provide information that is not public. And so a few courts have wrestled with this, and a few bar associations have wrestled with it. And so, for example, the California Bar Association has said there is no loss of the privilege provided there's a confidentiality agreement, an NDA in place. And NDAs are very common when entering into these agreements. The New York Bar Association takes a slightly different tack. They say, well, the information about the funding is not relevant to the merits of the litigation and therefore isn't discoverable anyways. Now, I stop there and say that what bar associations have to say about privilege and other ethical issues are not binding on courts. So lawyers have to understand this, but also understand the limitations of a pronouncement of a bar association on our ethical rules. The ABA also has some model rules and commentaries about this, mostly about getting informed consent. But lawyers should really think hard and think long about what information they are providing to litigation funders in the process of the funder deciding whether or not to invest in a case. The second issue there is independent judgment, and lawyers have an ethical obligation not to take on a representation where the attorney-client relationship will be materially limited by the lawyer's responsibility to another party. So in other words, if the funding arrangement gives the funder rights, either in settlement or strategy or anything else like that, the lawyer could be materially limited in the advice it gives to its clients, which is prohibited under our rules. Some states, most states bar the sharing of attorney's fees. And one state, Arizona, has recently changed one of its model rules regarding non-lawyer ownership in firms to try to aid or make it easier for third-party funding arrangements to share in the lawyer's fees. So there's a lot of going on here, but the independent judgment rule remains. And the third area, the ethics, is we have an obligation, lawyers do, of competence. And this includes providing our clients with adequate guidance on litigation funding, understanding the industry, understanding how the funding arrangement works, and understanding now the patchwork of local rules around the country regarding disclosure requirements. In the absence of congressional or even statewide action on this, there are some local courts who have instituted disclosure rules. They're not uniform, but it is our obligation as lawyers to understand what they are so that we can do our job in an ethical manner and consistent with the rules of the court. So those are the three areas for attorney ethics. And some of them then overlap with the disclosure issues. On one hand right now, so I'm going to slightly change topics. On one hand, we have the litigation funding industry who says, you know, the expansion and the maturity of the industry is great. There have been no major reported scandals, and therefore it's working fine without disclosure. We should go on and not have any disclosure obligations. On the other side, we have tort reform associations or similar entities who are advocating for mandatory disclosure, and in some cases arguing that there should be a prohibition on litigation funding under various theories and concerns. One is, does this encourage social inflation? You know, the investment of a third party, does it drive up the costs of litigation and the resolution of disputes? That's one concern. Another concern I've heard is that, well, we don't know who the funders are funded by, who owns and who is invested in the funding companies. Are there national security issues? For example, if a foreign wealth fund is one of the investors in the litigation, are they going to have access to information they would not otherwise have access to? Now, what I'm going to talk about, though, is in between those two issues, which is disclosure. To me, we don't have enough information right now to make a good public policy or legal determination on whether these concerns are legitimate, whether they're overblown, or what the remedies would be. We just don't know. The litigation funders rarely disclose their backers and what they're invested in, what their source of capital is. Congress realized this and commissioned the GAO, the Government Accountability Office, to provide a report so that our political leaders would have information in order to guide recommendations and implement changes and remedies as necessary. The problem is, when the GAO came out with its report, it admitted and disclosed that there were significant gaps in the availability of market data. And so the information that the GAO provided is in itself really limited. How do we get around that? Well, one of them is disclosure. We can't make good decisions without the data, but there are other issues as well. First of all, disclosure of litigation funding can aid in pretrial resolution. At the beginning of every case, defendants are often required to provide information about their own insurance coverage. Is there any insurance coverage that might cover the damages that would be assessed in this case? And that helps the parties understand the other's position and what kind of assets are available to cover a loss. Well, the other side of that is that it can be true the same way on the other side, meaning that when we go into settlement discussions, it's important to understand what the other side's motivation is. And so sometimes a plaintiff will be looking to maximize financial return. Get it. Other times, a plaintiff may be interested in things that are non-monetary. For instance, having the defendant make business changes going forward, or something else. And understanding those motivations is important. So if there's a litigation funder involved, we would know that going in, and either the mediator or the judge or the parties can then align their expectations and understand what might get this case resolved before it has to go to a trial. The other part of disclosure is it can aid in avoidable conflicts. We need to understand this. A judge would likely want to know whether she is invested in a company that provides funding for litigation. We routinely disclose information about the defendants and all of the parties to the judges, regardless of this, so that the judge can understand whether they have an actual conflict or whether there's perhaps a perceived conflict. And so this is along the same lines. A judge may very well want to know this information. And then the third issue with disclosure, it alluded to it before, is that it's going to aid policymakers. Without this data, policymakers are a little bit in the dark, and they're having to provide remedies and recommendations without understanding if the perceived problems are real. We generally want to avoid prescribing remedies when we don't know what the sickness is. And the only way to get there is by disclosure. How often this happens? What are the problems? I think we're going to talk in a minute about a pretty high profile issue that has come up recently involving Cisco. And I'm not going to get into that now because I know there's going to be a question on that. But we just don't know, for example, how often is the plaintiff who prevails wind up owing more money than the litigation funder, or owing more money than they've collected in the litigation. We just don't know. The funders tell us this doesn't happen, or if it does, it's an anomaly. But without data, we just don't know. And the light of disclosure can help policymakers understand this and prescribe remedies. So I know I've just said a lot of words, Jerry. So I'm going to stop there for a minute and let others jump in, and we can talk about either those issues or related issues.
Yeah, thanks, Michael, for walking us through some of the legal ethical issues and also the importance of the disclosure. You mentioned also public policy. There has been a bill introduced a couple of years ago that hasn't gone far, that was sponsored by Darrell Issa, representative from California, and Andy Barr of Kentucky, with Congressman Barr pushing the GAO to write the study, the GAO study you referenced, which came out last December, which, as you say, does not have all the information we're looking for. But you also mentioned Arizona in the context of independent judgment, and Arizona now allowing ownership of law firms by non-lawyers, which is getting a lot of attention, raising some eyebrows, because what does this mean? Are law firms or partnerships or LLCs going to become corporations? And if they do, if law firms, partnerships, and LLCs become corporations, then you're going to introduce a CEO and directors and officers, and they have a duty of loyalty to their shareholders, whereas the attorneys of the law firm have the duty of loyalty to their clients, and those two can easily conflict. So this is a trend which I think needs to be followed. So yeah, let's talk a little bit now about something that's happened more recently. I mentioned at the outset that the Wall Street Journal had a piece written by the editorial board. Caroline, I think you've seen that piece. You want to give our listeners a little bit of a walk through that journal story?
Sure. Yeah. Thanks, Jerry. Yeah. So that came out towards the end of March. And that's about a specific case involving Cisco Corporation, which is the large food distributor in the United States, and Burford Capital, who is one of the largest, I actually believe Wall Street Journal cites them as the largest third-party litigation funder in the United States. So Burchard more or less approached Cisco via their attorney Boyce Schiller, who Cisco was also using the same attorney at the time, to fund some antitrust litigation against some meat suppliers. And they entered into an agreement with one another. And Cisco was apparently ready to settle with the meat distributors. They felt that there was a reasonable settlement being offered, and Burford stepped in and said, "We disagree. We're not going to allow you to accept this settlement." And so that raises a lot of those issues that Michael was talking about, with some ethical problems surrounding this funding, where the plaintiff is not allowed. They were barred from getting what they wanted out of the case. And so that's obviously a big problem. And this is with a huge food distributor like Cisco, who's got a lot of money in their own right, got a lot of influence and power, and they are now embroiled in a legal battle with their litigation funder, trying to say, hey, we're ready to settle, we're ready to move on. And they are being currently barred from doing so. And interestingly enough, I believe, Jerry, you spoke about Burford being on 60 Minutes, and the CEO said, you know, our clients, they're free to run their litigation how they see fit. However, we're seeing, you know, according to the Wall Street Journal's reporting, that that's really not the case. So we see some real world examples of this being a big problem.
Yeah, thanks, Caroline. And that's as we said, it's a very current thing that's come to light. And we also said at the outset that the phenomenon of third-party litigation funding is one that has recently emerged and has captured attention. The numbers are pretty big. According to an annual report that's done of the industry, there's now over $13 billion in assets under management at litigation funders, which is up 20% in the last 2 years. That's pretty strong growth considering the environment that we're in and the capital markets environment. But it actually, third-party litigation funding does go back historically. So let's look a little bit at the historical context. It was known as champerty. Champerty and maintenance were these doctrines of law which have been prohibited really for a couple of hundred years. In the 18th century, the book that the founding fathers of our country had on their desks next to the Bible was Blackstone's Commentaries on the Laws of England. And in there, Blackstone defines champerty, which is the predecessor of third-party litigation funding, as becoming financially involved in litigation, and those that do are pests of civil society, officiously interfering in other men's quarrels. That was in the 18th century. And here, officiously meaning getting involved, intruding, and interfering with legal affairs. More recently, I've got an old set of the Encyclopedia Britannica in the attic from the 1940s, and in the 14th edition of the Britannica, in the section on champerty in the U.S., it said that champerty is generally criminal in the U.S. And those are old books, as Michael and other attorneys on the listening on the program will know that the book to look at now is not necessarily Blackstone's or Jerry's old Britannica, but Black's Law Dictionary, which I keep on my desk as well. And it characterizes champerty as the involvement of a third party, and it is officious intermeddling. So again, it's interfering with the proper course of litigation. And back to the Britannica, it relates the doctrines of champerty and maintenance to the practice of ambulance chasing. So ambulance chasing is actually a legal term, and it's in Black's Law Dictionary. And Black's, get this, says that ambulance chasing is a term that is attributed to the want of sufficiently high moral and intellectual standards for admission to the practice of law. So those are some unsavory kinds of practices which have been associated with litigation funding or its origins as champerty and maintenance, the terms that are forgotten by those who do not go to law school. So we have that historical context, and clearly the climate has changed. Michael mentioned that the litigation funders maintain that there have not been scandals, so it's not necessarily a bad thing. It's something that gives access to a little guy to have justice. But there have been some, what I consider unsavory associations of third-party litigation funding that have come to light. The phenomenon of patent trolls, non-practicing entities. These are companies that don't make a product, they don't contribute to product development, but they buy patents that are weak and that are unused. And then they take those patents and they sue numerous firms that have products whose patents are somehow related or similar to those. So really it's a shakedown, and companies will fork over $75,000 or whatever it costs to make this go away. And the patent trolls keep on doing this. There are several third-party litigation funders that have disclosed that they are involved in funding this sort of patent trolling phenomenon, which has been characterized as a shakedown. And patent cases have gone up 61% since 2020, according to Bloomberg. Another unsavory manifestation that was found out not so long ago was in New York State, where there was an illegal planned or staged accident scheme that was worth $31 million that involved about a dozen complicit attorneys and medical providers that would hire homeless people or other indigent folks in the streets of New York and ask them to act as if they're falling into a pothole so they could be sent for expensive surgeries and repeated surgeries that were not warranted, that were not needed, but they were just driving up the bills. Again, this was a $31 million operation. That was another attorney in that scheme that was arrested just a couple of weeks ago. So a current scheme. You have also asset recovery. You had some of the third-party litigation funders involved in recovering the assets of a Russian kleptocrat billionaire divorce settlement that should have gone for $700 million. It only went for $186 million. And the wife, the ex-wife who sued, got less than the litigation funder did. Didn't get the 41% of the $1.5 billion fortune that was supposed to be their marital assets. She got closer to 10% of that. And then more than half of that went to the funder. So this also is something that raises eyebrows. And Michael mentioned national security. This is something that has gotten attention in Washington on the Hill. The junior senator of Louisiana, John Kennedy, wrote a two-page letter to Merrick Garland, the Attorney General, focusing on the potential for a hostile neighbor or unfriendly country, think China, Russia, Iran, having their Saudi Arabia having its sovereign wealth fund investing in third-party litigation funding that is funding the lawsuits of a defense contractor or a sensitive U.S. industry. And if they're tied up and they're embroiled in officious intermeddling and their finances turn south, the reputation goes down, that could adversely impact U.S. national security. So it's captured attention, not just in the Justice Committee, but also armed services. So this is a multifaceted phenomenon that I think needs continued attention, and I'm glad that we have you, Michael, and Caroline here to talk about it. Now, if there are questions, please feel free to ask them at this time. We've gone almost 30 minutes. We've got at least 5 minutes for questions. And while you think about questions, I'll characterize the industry a little bit more. There's two main types of litigation funding, and the one that was discussed at the Caroline mentioned the 60-minute show where Leslie Stahl interviewed a couple of people after she interviewed the CEO of Burford. That show focused on personal or consumer litigation, and there is room for that. There's a branch of litigation funding which advances money to individuals who have trouble suing because of the expenses. Think of the ACLU that brings a class action complaint against a company that may have unsavory practices, sexual discrimination or harassment. So there is social justice litigation funding, which is like what the ACLU does, and that goes to the individuals that are the plaintiffs, again, not to the to law firms. So you have that also for medical bills. There's factoring where there's a lien or a loan that's advanced to an injured plaintiff to pay for medical bills, so long as it doesn't become usurious and you have interest rates approaching 40, 50 or higher percent, which has been done in some cases. So you've got the personal litigation funding on the one hand, the consumer, and then you've got the commercial litigation on the other hand, which has been the source of these numbers, the $13.5 billion, largely the commercial types of litigation. And then, Caroline, in your research, have you seen the kinds of allegations or the kinds of lawsuits that are common in third-party litigation funding that we know about?
Yeah, largely patent infringement, intellectual property, and products liability. Those seem to be the three big ones, and it's all with multiple defendants. So it certainly appears to be seeking out as large of a payout as possible. When it's not against a single defendant for a single issue. It's typically against multiple defendants. Yeah,
because if you have that, then you have the potential for getting the larger settlement. Right. Think of the asbestos or tobacco and more recently talcum powder or mesh, PFAS. So here you have the potential really for what the insurance industry has been fearing for some time as what is the next asbestos. And one of the reasons why R Street chose to focus on this subject is because R Street has done extensive research and publication and speaking on the phenomenon which Michael mentioned before of social inflation, which is the increase in loss costs that are settlements and judgments, jury awards that are greater than economic inflation. People are focused now on economic inflation in food and building materials and wages going up. That's economic inflation, consumer price index. But when you have social inflation that's higher than economic inflation, that's driven by factors which are societal. What's the value of a life? What's the value of an injury? What is the proper standard of care for an obstetrician or for some other professional? So when that goes up higher than the CPI, then this is societal, or it's called social inflation. And we maintain at R Street that third-party litigation funding is a driver of social inflation, because you have the average case size for single cases, according to the annual report of the industry, is about $4 million. And for portfolio cases, because funders can invest in an individual lawsuit or an entire law firm portfolio of lawsuits, is about 10 million. So these are big numbers. And this is what attracts these kinds of suits and this kind of funding. So when you have more mouths to feed, when you have a funder in addition to the law firm, then you need to drive up the award so that all the mouths can be fed. And when you have the plaintiff receiving less than the attorneys that are getting contingency fees, then I think that's a problem. That's not justice. That's really pecuniary. And in the investment community, this is known as an alternative asset class. You know, put your money in stocks and bonds, but to diversify with an uncorrelated asset class that's unrelated to the vagaries of the capital markets, then why don't you invest in lawsuits and earthquakes with cat bonds and litigation funding? So it's about the money. Follow the money is an old rule, which is one that can guide further elucidation and explanation of what goes on in this industry.
Jerry, I know there's a question in the chat, and I can give you a second to read it. And I'd like to make, just as you're doing that, make 2 points. One, some jurisdictions are acting on their own. Northern District of California, New Jersey, and a couple of states on disclosure. Maybe that's okay that we have this patchwork, but I think there's a strong argument for a uniform approach, and consistent treatment throughout jurisdictions is better. The second point that I'd like to make is there seems to be little downside on the disclosure. Disclosure amongst the parties and disclosure to the court does not mean that a jury, for example, will know that there's litigation funding. Just like a jury right now does not know that an insurer might be responsible for the liability of the defendant, a jury would not know that a litigation funder is the one that would stand to gain with a plaintiff's verdict. That's different than just disclosing this amongst the parties and to the judge. I wanted to make those 2 points.
Yeah, thank you. And thanks for pointing out the other question in the chat box, which asks for more color on the $31 million scheme. That was or is a staged accidents scheme or scam. Staged accidents can involve people falling down and then suing the owner of the property, or they can involve, this is something that's happened quite a bit in Louisiana, where you have organized criminals that rear end into a car in front of them, and they maintain that they've got neck injuries that require spinal fusions, which cost $100,000. But really, there's no damage to them. They're intentionally getting involved in these accidents. And the $31 million scheme in New York State, and focused on the southern part of New York City, involved the recruitment of actors that pretended to be hurt and falling down into potholes. And then the attorneys involved would steer them to medical providers who would charge 2 or 3 times more than the normal and customary charges. Those full amounts weren't actually paid to them, but they were the ones that were presented in court. So you've got phantom damages there that are driving up these payments to these conspirators. So it's a crime. Stage accidents are a crime, and you can look it up. Adrian Alexander was the ringleader, and several attorneys and doctors were involved. And this reminds me of what the Britannica said about a lowering standard of ethical practice in the legal profession. I want to ask Michael to comment on that. And if there are not other questions, then
I will say there is one other question, Jerry, and it's about what kinds of cases we may be seeing more frequently. I'll add, Caroline made some good points. We're also seeing the increase in antitrust cases in particular. The more sophisticated litigation funders are using big data to decide what cases should be brought, how much return on their investment they can reap potentially. And so we're seeing cases where lots of data can be used to maximize the evaluation of cases, and the return is an area we're seeing. But I'll add to that we're also still in the dark a bit because we have the lack of disclosure. We just don't know for a fact. The litigation funders are in control of this data, but as I mentioned earlier on, Very rarely are they sharing this kind of data that would be helpful to independent analysts to take a look at this.
Yeah, and to add to the kinds of cases that we see or expect to see more of, products liability, I think, just as the insurance industry is researching what could be the next asbestos and looking at substances that are in the air or in the water or enter people's bodies, so that they can prepare themselves for how to deal with that and defend against that, and how to respond and loss control and to mitigate risk. Just as the insurance industry is looking at what could be the next asbestos, the plaintiff bar is also looking for the next gold mine in terms of products liability. And is it PFAS? Is it microplastics? Is it methane emissions from areas where there's food industry? So products liability is a big one, because it can affect millions of people, and so the numbers there are can be really high. Just the other day, the $4.5 billion settlement with Johnson & Johnson on talc is now up to close to $9 billion. Numbers keep rising there. So products liability is an area that is probably going to get hotter, because it has those big numbers. Well, if there's no further questions, we'd like to thank you for being with us, and feel free to let other friends or colleagues know about this event. The recording will be available. Thank you, Michael, and thank you, Caroline, for this stimulating discussion. I learned a lot, and I hope you did as well. So this is Jerry Theodorou saying thank you.